we're really honored to host Professor David Nelken from King's College. I could read you his resume, but that would take about a half an hour. So I'm just going to go through the strong points. He's a professor of comparative and transnational law and former head of research at the Dickinson Poon Law College at King's College in London. He has also taught at Cambridge, Edinburgh, University College London, and then from 1976 to 1989, before moving to Italy as distinguished professor of, I'm sorry, I got that wrong. So from 1976 to 1989, he taught at Cambridge, Edinburgh, and University College London. Then he moved to Italy in 1990 as distinguished professor of legal institutions and social change at the University of Macerata. I thought that was a dance. Anyway, from 1995 to 2013, he was also distinguished professor, research professor of law at Cardiff University. And from 2010 to 2014, he was visiting professor of criminology at Oxford. In sum, he seems to have a hard time holding a job. His research focus is on theoretical inquiry and criminal investigation in the area of comparative sociology of law, criminology, and legal and social theory. His awards include, don't talk about the awards. You can look at it at the flyer. I mean, it's like this long. He is a fellow of the UK Academy of Social Sciences, member of the independent board of the Scopus database of peer-reviewed literature, where he's responsible for evaluating all law journals worldwide. That takes some time, doesn't it?
In all languages, that takes a lot of bluffing.
A panel member of more practically, a panel member of the Scottish Children's Hearing Juvenile Justice System from 1979 to 1983, and a member of the Italian Regional Crime Committees in the 1990s. So, Professor Nelken, over to you.
Thank you, Mike. Listen, I really want to say how grateful I am for this invitation. It was by no means taken for granted, linked to a trip I have to make to Sydney as part of a research project on artificial intelligence with people there. And this chance to be here, and for me, the first time in Singapore, and the first time in this extremely high-quality university, is really special. So thanks to Mike, thanks to Andrew Halpin, who was part of it, to my colleague Andrew, and to Saguna, and all the people who've made this possible. Really, I do appreciate it. In return, what do you get? You get the world premiere of Nelken on Wikipedia's law. And even that only puts me more into your debt, because since it is my first time, I'm really looking forward to hearing your comments and advice about how to take this project further. And as it says on the board, I apologize to those who know more than me about Wikipedia, and there may well be people in this room who do, but also to those who know less, who may be bewildered by some of the things I take for granted. It's difficult to get it exactly right, because Wikipedia is a whole world to itself, as I shall hope to show. So I've got in my mind to do two things: to examine the question of the relationship between Wikipedia and law under the curious title, obviously, in opposition to William Twining and David Meyer's famous book, How to Do Things with Rules, How Not to Do Things with Rules, because Wikipedia is against having fixed rules. And under that heading, look at what we already know about Wikipedia and law, seeing it as an example of private ordering, which has public implications, and examining in what way it is or is not like state law. Then, having done that, probably not to your satisfaction, not even to mine, but in the time available, touching on some of the issues, I want to examine some of the evidence in more detail about the key puzzle that I'm going to share with you. And the key puzzle, as I say, as I've mentioned, is this denial that they have a legal system, or denial that rules should be taken seriously, whereas there are hundreds of pages, if you know where to look for them, in Wikipedia, all about the rules and policies and guidelines and essays about what needs to be done in editing an encyclopedia. Not the first place one would think that law would be relevant to, or law-like jobs would be relevant to, but as we'll see in the first half, that is not the case. They are relevant. And the evidence we'll look at to try and, if we can, make sense of this puzzle is what Wikipedia says and does about this issue of don't take rules seriously, and why it's got it in for what they call wiki lawyering, a term they've coined. We don't want wiki lawyering. We don't want people to behave like lawyers, even though we have rules. It needs interpreting, but don't do it like a lawyer. And the truth is, to really do this sort of job properly, you'd have to spend a lot of time going through the talk pages and the way, in particular, entries on the encyclopedia, the policies and so on are applied. All I can do is give you a brief exposure to that, dealing with two of the cases, Rachel Corrie's death and the entry on Polish anti-Semitism, both of which are, as we'll see, entries which lead to a lot of law-like interpretative struggle about the meaning and the application of three of the key rule principles of Wikipedia that some of you will know. That is that there must be a neutral point of view, MPOV, that anything that's in Wikipedia mustn't be something that you've made up. It's got to be verifiable. There's got to be sources for it. Wikipedia's encyclopedia, not like the first encyclopedias where, they were trying to bring the greatest experts in the world. It's an encyclopedia that doesn't want experts, it wants everybody. And verifiability means it's already been said. What goes into Wikipedia has already been established somewhere else. And reliability is another aspect of this. No originality and so on. Let's get going. So, why study the living law of Wikipedia? Why study Wikipedia? Wikipedia is important intrinsically. It really is an incredibly influential encyclopedia, the 10th or whatever site on the internet that people look at. And at this time of fake news and the rest of it, if you can believe Wikipedia, and apparently it's getting more believable, then it's an enormously important human treasure, because everybody else is trying to manipulate for various commercial or political reasons the truth, whereas Wikipedia may be telling us the truth. It's also an economic and political experiment. As economists will know, the so-called problem of the tragedy of the commons. When you have something which everybody benefits from, some people take too much advantage of it, and it soon collapses. Look at the ecology. Look at my experience this morning in the Botanic Garden here, where they say, well, yes, we've only got 5% or 2% or something left. There should have been more. So there's the tragedy of commons. Is Wikipedia an example of the triumph of the commons? They found a way, by turning copyright inside out and so on, to make this unusual success of an economy based on volunteers, not on commercial advantages. There's lots to be said about that. We won't have time probably today to discuss it further. What is the commercial aspect? Is it in the background? But certainly up front, Wikipedia is a non-commercial undertaking where the tragedy of the commons has been avoided. As a political experiment again, it's seen as an example of collaborative anarchism. And I have a son who's an anarchist, and I can tell you that often the anarchist groups he's part of are not very good at collaborating. So if really you've managed to succeed in making, like herding cats, anarchists collaborate, you've done very, very well. Again, is it such an example? Has it succeeded? Has it really got a hidden oligarchy of things that I discussed and debated, but won't be taken further here? What we're concerned with here, and of course these larger things are relevant, but what we're concerned with here more specifically in a law school amongst colleagues mainly dealing with law and lawyers is to understand the legal aspects of Wikipedia, starting from the fact that many people claim it is the world's busiest dispute processing system, which gives it some claim on our attention. And as a professor of transnational law, it also has some claim on my interest as one of the ways in which, at an international, global level, forms of law jobs are being achieved in some way. This subject has been studied before, but obviously since Wikipedia is young, not that much. In 2011, somebody said that we need more examination of Wikipedia's internal legal structure. So people were saying it has law, in case there's still some people amongst you saying, what's Wikipedia got to do with law? And it was suggested that you need to get down to the practices and procedures. Well, that's what we're going to do. So I see Wikipedia as an example of private ordering, like and unlike other forms of private ordering that many socio-legal scholars know, the people with the diamond dealing who don't go to the state but sold out amongst themselves, the whalers that Erickson talks about who find ways of deciding who gets which whales without going to the state about it. It's an example of private ordering. It's sorting out Wikipedia's own problems, which may or may not be our problems of getting to the truth, but they're trying to sort out their problem of avoiding what they call edit wars, avoiding conflict between those people writing articles of Wikipedia that gets out of hand and blocks this great ongoing project. It's almost this Tower of Babel project that they're going to create a universal knowledge. We're talking mainly about the English Wikipedia. Of course, their Wikipedia is in lots of different language. But it still has this universal, even more, especially in a non-universal language, this universal ambition. So it's about private ordering, and it's relevant to social norm theories, when norms grow up and so on. And already in 2009, I mentioned something about Wikipedia in writing an article about Eigen Ehrlich, the founder of Sociology of Law, and I quoted from Mitchell, whose comments as a member of the social norm theorist school, whose comments about people like Ellickson and Bernstein, the private order people, was that they were drawing too sharp a line between state law and what went on in the systems they were describing. Because even if the rules and procedures the whalers used or the diamond people used didn't correspond to what would have happened with litigation if they'd gone to the state, nonetheless, the deepest issue was they had an idea what law was, said Mitchell, and the idea of what law was they'd got from state law. So that, I think, is relevant for us in looking at Wikipedia, because, as I mentioned, this puzzle about saying they haven't got law, whilst in some respects doing law, means that, unlike these private ordering cases, Wikipedia seems to want to get legitimacy by denying that it's legal, whereas normally people get legitimacy by claiming that they have, they're doing things in a guaranteed way according to the normal principles of law, and therefore their authority, their power turns into authority. But Wikipedia doesn't want that. There are important ethnographies written by editors, and there are many editors of Wikipedia clearly who write about their work. The two most well-known are the ones on the board at the moment. But if you're interested in law, and I've been looking for what I think are the best stuff on law, it's a lot written, but it's, it wouldn't surprise you. One of the best pieces is an undergraduate thesis, in which Geiger says, if you want to understand legal culture, a term that is music to my ears because I've written about legal culture. If you want to understand legal culture, you have to get to stories. You have to understand how the thing works. But curiously, maybe as undergraduates do, he lost confidence and wrote saying, well, no, actually, I'm not going to, it wasn't right. No, I've realized that I had this idea that law is always one thing, that there's a universal idea of law. So he promised he would do something else. He never did it. He never did write about the independent, hard and soft norms, formal and informal networks. So that's what I'm doing a bit today. He never did it. What did he do was, I think, very important. He moved into the study of the role of algorithms in Wikipedia, because Wikipedia has law in the sense that we know it or used to know it. The attempt, in Fuller's words, of subjecting human behavior to rules. But Wikipedia, dealing with the problems of vandalism, people come and vandalize or disrupt other people's entries, or even beyond that, in how to write the entries, is more and more coming to rely on algorithms and bots doing that job for them. And that's what Geiger's been writing about a lot since. He's written at least 10 articles about that. And he's right. I mean, that is very important. But I'm sorry he didn't revise his undergraduate thesis. The other key, for me, source of our understanding of Wikipedia and law, I would suggest, is a wizard of a thesis by, by Oz. She hasn't published it. She has a lot to say. I won't suggest you be able to read all that, but you can see that her key concern is things like legal norms floating in a sea of anarchy. Strange phrase. I'm always suspicious of metaphors. Legal norms and the idea of playing. She has a lot about playing with the law. So, if I'm going to have my 5 minutes of fame, I have to disagree with her. And I do, in a sense that I am going to try and persuade you, particularly with the actual examples I'm going to give you, that there's not much playing going on. I know playing can be given lots of different meanings, but I don't think it is playing. She is drawing, some of you will know, on Susan Silby's idea that there are 3 ways of hegemonically in which people in the West relate to law. They're either, against it or for it, seeing its majesty, or they're with law, they're manipulating it. And so she sees Wikipedia as an example of people manipulating rules. I don't think so. This anxiety not to be like state law, this insistence that don't take rules seriously, whilst at the same time referring to rules and policies the whole time, certainly needs explanation, but I'm not convinced that the explanations that they're playing. All right. Let's get to the basis. Some of you will think I'm taking too much for granted. Does Wikipedia have a legal system? In what sense does it have a legal system? Well, those who would say yes, of course it's only semi-autonomous from state law. Wikipedia, and people sometimes forget, couldn't work unless it had got from the state law a concession that it can't be sued for libel. It wouldn't work if there wasn't as in the rest of the internet, commons licensing, for which you were allowed to put things in Wikipedia and copy from Wikipedia, as long as you then ensure that other people can copy from you. That's the way of getting around copyright law. It has law-like institutions, both for the discussion of articles, for mediating when people can't agree, although that never worked out, the mediation stage, and arbitration, as we'll see later, is crucial. It has law-like actors called administrators, stewards, checkers, bureaucrats, and so on, clerks, and so on. It has law-like discourses, norms, guidelines, policies, principles, rules, and essays. And there are hundreds of pages setting all these out. And each article, not every article, but many of the articles have a talk page, which is like going down a rabbit hole or getting into the back room of Wikipedia, where the people who are actually creating that page are arguing what should be or should not be in it and making reference to all the crucial policies and the rules. Equally, you could argue that it's law-like or has a legal system in the sense that the functions being performed are ones familiar to us as laws. Dispute channeling, social control, stopping vandals, and so on. And there are sanctions and incentives, some of them quite original ones. Banning from editing a particular article, banning from any work in Wikipedia for a certain amount of time, rehabilitation, letting you back in again on appeal, and barn stars. What Jeremy Bentham would have approved of, he would have said, why don't we do incentives? Why do we always do sanctions? Oh, we said because we couldn't afford to do. Well, they found a way we can afford to. You give them barn stars, it doesn't cost anything. It's like stars in primary school, elementary school. If you've been a good boy and Wikipedia, done a lot of good things, you get barn stars as your prize. So there is a certain element of social control going on there. And law has a history in Wikipedia. It didn't start with law. At first, it was, if you like, informal. Then in 2003, about 3 years into the project, it became clear that Jimmy Wales, who invented the thing, couldn't deal with the disputes coming to him. For those of you who know your Bible, it's a bit like when Moses is told by his father-in-law, you can't deal with all these cases, you've got to set up a legal system. And somebody comes and tells, who tells Jimmy that you have to set up a legal system? The guy next to him, Alex Rorschach, who's a lawyer from New York, and a member of Wikipedia, editor of Wikipedia, and he sends him a whole worked out set of procedures, starting from negotiation, going through mediation, and arriving at arbitration, exactly as we who study dispute processing know it works. And he gave him a simplified version of the arbitration procedures actually in New York at the time. The man next to him is known as New York Brad. On Wikipedia, people tend to give themselves made-up names. New York Brad has been for a very long time on the arbitration court, ArbCom as it's called, and so he's known as the informal Chief Justice. On the other hand, if by law we mean something relatively formal like arbitration, look what's happened to the number of arbitrations. At first, when the thing's founded, a lot of cases are now down, but really down. For the thousands and thousands of disputes going on in Wikipedia amongst editors, we now have, the last 2 years, last year was 7, and this year I've checked 6 cases going to the arbitration committee. That's not very much. No, you could say that shows law already worked, the norm's settled, there's no need for fighting. Or you could say that it's not really about law. It's not due to the number of editors declining. There is some worry always in Wikipedia that it's dying, that editors aren't coming forward anymore, there's nothing left to be done. They've gone down, but nothing like in the same way. More important than whether people are going to the arbitration committee, though that is important as well, is the way, as I've mentioned, that Wikipedia keeps saying we don't do law. So you have all these rules and policies, and you say, but we don't do law. So its rhetoric is against it. It says things, and we can divide into 3 aspects. We can talk about their general ideology. We can talk about why specifically a project of writing an encyclopedia is inimical to the use of law. And we can suggest that more than not being appropriate for law, after all, you can't go litigate in the way that you might in the diamond industry or the others if you don't get agreement. What are you going to do? Somebody doesn't agree with you about your entry, you can't go to the state. So, but more, in so much as there are disputes and they do need to be dealt with, there may be no need for law because there are other ways of handling them other than law. So briefly, on the ideology, the people who do Wikipedia come out of the same cyber libertarian battles of those who created the standards for the internet, ICANN, and who fought against attempts to curtail free speech and to close down hackers and so on. So that many of the same issues overlap, many of the people are the same, so they are against the state. So by being against law, they're really against regulation or against state regulation. That's what it means. Secondly, you don't need it for this project. Well, law gets in the way of editing an encyclopedia because that should be based on a rough consensus, not on people's rights. It's not a question of having a right to have your entry. It's that you've got to get the community to agree, which is a whole different exercise. And of course, not everybody will agree, and it doesn't just go by majority. Very curiously, very interestingly, it goes by good arguments. Wikipedia's notion of itself is those who have the best arguments, you don't have any further discussion after that, of course. We as lawyers would say, but that takes some interpretation, doesn't it? And then they say that policies and rules are actually used by those who don't win consensus, and that's why they're worried about policy and rules. And they worry that it becomes disruptive to the exercise, that it stops the ongoing project of doing the encyclopedia. People sort of take a stand on a rule or policy. They might even be right that somebody else has edited in a way that has not followed the rules and policies, that something is not notable when it, even though it's said to be notable or not well so. But if you get too caught up in that, then they find that blocks the ongoing project. Then somewhat inconsistently, but who's consistent, they suggest that the real problem is that rules are being applied inappropriately. In other words, that they could be relevant, not that you don't need rules, but you shouldn't be using them inappropriately, which to me at least begs the question, then there is a notion of appropriateness. So therefore, this is a bit like Oz said, there is something about playfulness. Taking rules too seriously stops you being playful. Well, then there's a sort of strong, I think, Christian influence. The letter gets in the way of the spirit. The letter killeth. So that there's this sense that rules and policies are about letter, and the spirit of the project is something which can be killed if you take the letter too seriously. And finally, in terms of needs, you don't need law. Well, everybody's anonymous. You might think that makes social control more difficult. Answer no, because unlike most activities in social life, this is all readable and visible. It's all there on the net. You may not give yourself your right name, but people don't care what your name is. They're going to say, whoever you are, Joe Bloggs, you've done the wrong thing. You can control, you can see what's happening. Nobody can hide. It's a sort of panopticon, for better or worse. So maybe social control is easier. We don't need law. Secondly, and not irrelevantly, much of the standard work of controlling against people who are not editing in the correct way or trying to stop other people editing is being done by algorithms and doesn't need human intervention. They also claim they have a picture of ants in a fire continually burning. I can't show you the video, burning and fire collapses and the ants keep burning. That principles are always in movement. If the principles are always in movement, you don't want to fix it in rules or policies. And they have this interesting slogan underneath that video, guided by principles, bound by no flaw. Now, bound by no flaw means, to those who know Wikipedia, that you can always revert, that they encourage people to add things to any article because the next person is maybe other people, if the articles are important ones, checking the whole time. And if they don't like what you've added, they'll just revert it. So don't worry. So bound by no flaw, it's an encyclopedia, unlike written encyclopedias, text encyclopedias that can always improve itself. So guided by principles, bound by no flaw. They're bound by no flaw is also, I'm sure, deliberately making you think of law. Of course, we'll mention later briefly, principles versus law. Don't we have principles? Doesn't Dworkin tell us that law has rules and principles? But okay, we're not here to give marks to the Wikipedians for their knowledge of legal philosophy, but it is relevant for us. Okay, now let's talk about, now that we've established, I hope, more or less to your satisfaction, there's something going on here. There's some contradiction between needing or wanting rules and policies, on the other hand, not wanting them. Let's see how this works out in practice. It works out in practice in various ways, but we'll take two examples which seem to highlight what we're talking about here, this contradiction. One is the insistence that despite having rules, they have no firm rules. They have 5 big pillars, and the 5th pillar of Wikipedia, the first one's a bit boring, this is an encyclopedia and not anything else. Although there's hundreds of pages of what it means to be not anything else. But it's an encyclopedia. But the interesting one from a legal point of view is number 5, which says there are no firm rules. And then there's also this no wiki lawyering. And they contrast the legal world to Wiki's world in saying that law's all right in that world where technicalities are important, in the rest of the world, and should be. So they've got nothing against law as such, despite being cyber libertarians, in its right place. But this is not the right place, using technicalities here. Well, we'll see. So, ignore all rules. There's about, one of the main sites on that has many, many pages, and one of the key phrases is, some rules may be enforced, but the written rules don't set accepted practice, don't take a too strict interpretation of letter without consideration of their principles. If the rules prevent you from improving, ignore them. Many of the reasons that I've mentioned are not always consistent, are mixed up here. But I still don't think it's anything to do with playing. Remember, that was what I'm arguing against. We would say, rewrite, if it's a PhD student. But it's not about playing. They're trying to square the circle. I think that should be interesting to us, this effort to square a circle of both having and not having law is what interests us, but I don't see it as playing. Why are they trying to square the circle? Because they don't want you to abuse the rules, and which means there have to be rules, otherwise how can you abuse them? But they don't want you to take rules too seriously. Taking them too seriously is, if you like, one of the ways of abusing them. Interesting. And then there's a prohibition of wiki lawyering. This is from the site. They actually have this guy as the foil of what they're against. Again, I can't take you through everything they say about wiki lawyering, which is long, but there's so many things they're trying to get at it, which is, if you like, a further development of this idea of not having rules. They're not two separate things. If you want to make a legal philosophy out of it, which I don't recommend, it would be the continuation of their non-rules philosophy. It's trying to use a policy or guideline in a way that is different from compliance with the policy, making it more strict, violating its spirit, willfully misinterpreting it, weaponizing it. Then it can also be used to stop finding solutions and not to be commonsensical. And they give a good example, which every lawyer would recognize, the three revert rule. One of the ways of stopping people going on with these edit wars forever is to say that if you disagree about an entry, you're allowed to revert, that is to change what the other person you don't like has said about it, up to 3 times. After that, you're not allowed to do it in any day. So people get around that by doing it 3 times every day, which is not going to the exercise. More than, they have a continuum. They say, well, mild meaning is they mentioned 73 official policy pages, 280 official guideline pages, and many are obscure. So you can't hold people to that, So don't be too tough on people if they haven't got the rules right. Don't try and enforce But I mean, read Twining and Myers on how to do things with rules. The issue for lawyers of whether a rule overlaps perfectly with purpose is one of the key issues for lawyers. It's very difficult to have any statement of a rule perfectly match its purpose. Sometimes it'll go less than the purpose. Sometimes the purpose will go further. So it's very important, very interesting to me how far the complaints they're making about law are ones that anybody would make about law, even in the state law system. And therefore, they're even more like law than they are recognizing. The worst case of severity is the weaponizing to bully other people. You're not keeping to the rules. Well, I imagine some bullying goes on in the real world in law as well. More funny is the fact that you can misuse this misusing behavior. In other words, if you say to somebody else, you're wiki lawyering, that too can be a problem if they're not really wiki lawyering. So they then try and control for that, especially new people who come in and say, but doesn't the policy, we're going to have to see an example, doesn't the policy require this? They, oh, you're wiki lawyering. Huh? I was just trying to do the rules. No. And finally, but last but not least, another example of misuse of the term is when it is known that an editor actually is a lawyer. And they go, hey, you're wiki lawyering. Well, I'm a lawyer. Okay, we won't have time to go into this because, as I feared, it's taking longer, but I just put there that it's clear that absence is presence, that what Wikipedia is struggling against is one specific idea of what law is, right or wrong, and one particular tradition of law, Western or even American adversarial law, and not, for example, religious law, Jewish or Muslim law, which is far more like Wikipedia. Arguments that go on based on interpretation for a long time. Okay. So let's, in my last minutes, look at some trouble cases to see, again, how these things work out in practice in the everyday life of Wikipedia's living law, and why I insist that, at least for these sort of cases, the point doesn't seem to be concerned with playing with the law. What actually happens? Well, there are disputes over the meaning, as you'd expect there would be, about notability, verifiability, and bias. If I may just interrupt, there's a debate about whether Nelken should be on Wikipedia. I have an entry, nothing to do with me. And somebody who put it in decided I was worth going in. And somebody else said, what's he doing? Why is he here? And I have a lot of sympathy with the other person. So the first guy says, well, he's a distinguished professor in 2 places. The other guy says, well, I'm not going to take it out. But look, nobody else comes on his case. Nobody else said anything about him. So clearly he's not really important. He's right. So notability is a controversial matter. What should be included or not? And so is verifiability, and so is bias. How do you get rid of bias? And then how do you handle these things is very, very, very interesting indeed. We'll come across it briefly here. The disputes are about content. After all, they're editing an encyclopedia. What I say about what happened in the Second World War is right. What you say is wrong. They're not concerned with other people. They're concerned with facts. And yet, especially when you get to the arbitration court, no arbitration court consisting of 14 people can know about the truth of all these incredible, wonderful array of knowledge in Wikipedia. So how do you do it? How would you do it? Much like law, you transform the dispute into something you can handle. Does family law deal with the real issues between husbands and wives? No, but it transforms it into what it can deal with, what it wants to deal with. The rest it leaves to social workers, psychologists, psychiatrists, or nobody. And so does Wikipedia. It transforms, when it gets to the hard edge of law, content disputes into content disputes. If you use the wrong language, if you were not respectful, if you didn't assume good faith, one of the big principles would be in the other editor you're arguing with, then we'll knock you down. We'll do something to you. We'll ban you. We'll stop you interacting with it. Okay. So, 2 examples of trouble cases, a term which anthropologists of law to get at the life of law. So poor Rachel Corrie was a part of a Palestinian-linked protest group. She was trying to stop what the Israeli soldiers were doing at the time and was killed by a bulldozer running her over. Big controversy about why that happened. On the one hand, was it because she shouldn't have been in that place? Nobody goes in the middle of a war situation without realizing they're taking a risk. The bulldozer guy couldn't have seen her. He had special bars over the windows to stop the stones breaking them, and she hid behind a mound of earth. Israeli side. Palestinian side and Palestinian sympathizer side, not at all. You could see her. You weren't looking for arms. You were trying to knock down people's houses. That shouldn't have been doing that anyway. She was a martyr. So somebody, I don't know who, and you never know who, this Rachel Corrie, objects to having Rachel Corrie into Wikipedia, far more serious than David Nelken, saying that she's not notable. Why? Because there's a policy, see how you quote policies, one event. If somebody's notable just for one event, then they don't get into Wikipedia. Well, it's just one event, you know. And so she said, I'm a bit scared about asking you. I know it's a very emotional subject, but, you know, I just read the policy, and she seems to be notable just for dying, and that doesn't get her in. This sets up, obviously, an incredible counter set of arguments saying that this person, a man or woman, I don't know, has completely missed the whole point. Wiki lawyering, you might say, though not yet accusing her of wiki lawyering. Taking policies seriously or misinterpreting the policy. Actually, she had a notable life. And then it becomes even more technical. This person who asked the question wants AFD, Article for Deletion, another policy, saying that whether or not the other people disagree with her about notability, since she is not a signed-on member of Wikipedia, and anybody can join Wikipedia, you can only do certain things. They tightened up if you were registered, not with your own name, but with some name. She's not registered. She's not. So therefore, somebody else has to do it for her, has to raise the question for the administrators, these hundreds of people who have an administrative job within Wikipedia, to raise the issue of whether it should or shouldn't be deleted because she's not notable. And the others are so unsympathetic to this whole thing, they don't want to do it. So she gets more and more angry, saying, come on, I have a right to participate, So eventually they do it, and as you'll no doubt be pleased to hear, she loses. It stays in. Later developments are even more interesting. Still with Rachel Corrie, Jay Clemens, whoever he is, who's been one of the leading people in fighting off this attempt to take the article out, he wants to write such a strong article about Rachel Corrie that he has to include everything, including the nasty things that right-wing sites are saying about Rachel Corrie. And one of the nasty things that right-wing sites are saying about her is that they call her Saint Pancake, because she'd been made a martyr, because she was flattened. And as it happens, because people were collecting money for Palestinians, do it by making pancakes and whatever, but pretty unpleasant. But this guy, the one who wanted her in, is insisting that you have this slur, this nasty thing. And this raises the question of whether it is verifiable. What are the sources for this? And he's only got two very poor, one sort of film magazine and one's some nasty right-wing site. But he claims. How many sites are necessary to be verifiable? I've got two, not just one. And the others say, but what about, the effect on her family? That you put these things, Wikipedia shouldn't be upsetting people. And he says, well, Wikipedia's not about if we're not going to upset people, we couldn't do anything with Wikipedia. It should be about recording the truth. So they keep arguing for 55 pages of argument. And he loses. Okay. Not much playing there. Policies come in the whole time. Look how many times. Each time WP, Wikipedia policy, gets used, gets argued about.
So just...
Yeah.
Did you say that the slur ended up being included?
No. Thank God, left out. Yeah.
Okay.
Left out. He lost. Final example, where it gets serious. We have an argument where you can't sort it out. I mean, this was sorted out by consensus in the sense that the guy never agreed, but enough people didn't think he had a good point that they decided you can have a good article about Rachel Corrie without including that unpleasant thing. When you can't sort things out, when the fight is just too deep, then it goes to arbitration. Not many cases, recently as we've seen, but it goes to arbitration because the project is at risk if people are having what are called edit wars and they go through not just one entry, but they follow each other around Wikipedia, crossing out what they've written in other things. They get really obsessed with the issue and with each other. And one such example is about anti-Semitism in Poland. There are some people who think that not enough is being made of the anti-Semitism in Poland. As you know, after the Second World War, things happened which shouldn't have happened then in terms of killing of Jews in Poland by Poles, and the books written about it. And on the other hand, there are Polish, obviously mainly Polish editors who feel that if anti-Semitism is a problem, being anti-Polish is as much of a problem, if not more, from their point of view, and therefore they are trying to stop any articles which put Poles into a bad light, and they present Jews as being the leading members of the Russian commissars who came in and took over Poland. There certainly were some of them, and so there's a lot of fighting going on there. So when they couldn't sort it out, when the history, or the history entries that had anything to do with Poland and with Semitism, Second World War, continued to be just a field of fighting, this was raised for the arbitration committee. They have a long discussion, just as an appeal court does, about whether they're going to take the case or not. A lot of discussion. And it's normally based on, what are we going to do about this? We don't know the facts any more than these people do. We can't sort this out. This is basically a conflict. What is it going to come to us? How's it going to benefit anybody? And then the pressure on the other side is, yeah, but these guys are messing everything up. You've got to take it on. No, you've got to deal with them. So you have to transform, as we said, content into conduct. And this is how it works, just briefly. There are motions to present the case. then everybody involved gives statements. Not under their real names, but under whatever names they edit. The key people here are IceWiz and Volunteer Marek. IceWiz worried about anti-Semitism, Volunteer Marek worried about anti-Polism. Statements by people knowledgeable about facts. Quite a lot. Preliminary decision about whether to go ahead and what to do. And that's followed by the actual decision, the final decision, in which they explain the purpose of Wikipedia, the rule, principle at issue, verifiability, because that's what it turns on. They can't just say, stop being bad boys. They have to say, you're not complying with the rules. The rules are, there have to be a verifiability. You with your stuff going against the Poles, and you with your stuff going against the Jews, have not used sources which are properly verifiable. I've looked into those sources. They're, in so much as we care about citations being a measure of anything, they're all cited. The problem is they're cited by their friends and people who believe in the same school of thought as they do. Very hard to say what is in history, truth of history. People keep rewriting history every generation, after all. I studied history in Cambridge, about it. So they go through these different issues, and then they come up with their findings that there has been bad conduct. Incivility, inflammatory rhetoric. They've assumed bad faith instead of good faith. They've been editing, like in a war, battleground behavior. Sock puppetry, for those who don't know, is changing your pretend name so that you can sort of come up, even though you've been stopped from doing something, you do it now under another alias. So these guys are so serious with what they believe in, and they're accusing each other of things. So then they come to action. The remedies for our two main people, IceWiz and Marek, they're not allowed to interact anymore. They're banned from editing certain topics. Then there's enforcement of these restrictions, motions about it, amended. The whole thing takes 2 years, for which they apologize later, because that's very long for Wikipedia. Wouldn't be long for an appeal court. The main thing takes about 3 months, but then for some reason the amendments took them another 2 years. Okay, so that's what happens in a case like that. We'll now end. Mike will be pleased because I'm running beyond time. Conclusions. So, this is new to me, as you will see. It's my best stab at trying to make sense and answering the puzzle, but I may have missed a lot of things. But my conclusions are three kinds. Firstly, maybe Wikipedia's law tells us that there's a sort of new kind of rule or rules going on. Maybe it tells us about a need for new rules, and maybe it tells us something about what Ehrlich meant by living law. So let's take the first. Our friend... a new kind of rule. So in 1998, so we're pretty early on, and I referred to in my 2009 article, it was suggested that the internet could never have legal rules which are binding, because in the virtual world you can't get the degree of uniformity and unanimity to have a custom which could then become a legal rule. It was a reasonable, sensible sort of suggestion, which would then become binding and obligatory. Well, but what Wikipedia sort of suggests is you can, but in this strange contradictory way, in which it's yet binding and not binding. Haven't squared the circle. The undergraduate guy they said, in fact, it's this having a policy that your social norms should be loose rather than tight is the way to do it. Interesting. Of course, the more you rely on algorithmic law, and this applies well beyond Wikipedia, the less room for discretion and interpretation. We're going through a world where things are tighter, not looser. And Wikipedia is run by a mixture of human and bot now, and it will be very interesting to see how this develops. It's on the one hand lighter and harder. What gets to do which? Now, the issues that Wikipedia people fight about have also changed. They're more and more not about history, but that was bad enough. What happened in the Second World War? That was big trouble. But it's now about what's happening today. Because unlike other encyclopedias, Wikipedia makes the facts that it writes about. So, writing the revolution by a professor in Sydney, not far from you, writing the revolution is about the Egyptian revolution, Tahrir Square. How the Wikipedia editors decide to call it a revolution, when and how they persuade others, and what significance it is, calling it not protest, but revolution. And the question of who makes the facts, Wikipedia 20 edited book all about. Wikipedia is written by men aged 25, on average, women 25% only. It's the first world that's involved, not others. Who is making these facts? This is something which goes beyond the normal, beyond the normal principles of neutral point of views, verifiability, and no original. That doesn't get at that. And clearly, in the most recent book, Wikipedia and the Representation of Reality, that it's about not are the facts accurate, but that facts are being made. And can you make that accountable? And finally, living law. So living law is often defined as the rules actually followed by social associations and groups in accordance with or defiance of state law. And that's how Ehrlich creates sociology law, something that goes beyond just the understanding of state law to understand that something like law exists in every social group or social association. But there's an ambiguity about it. Does living law mean what people actually do or what people should do in those associations? An ambiguity that has always bothered me. And I think Wikipedia shows that very clearly. Now, what Wikipedia actually does about its rules, as compared to what it says, the contrast between saying we don't follow rules and yet rules being very important, and more important the nearer you get to arbitration, is that something specific only to Wikipedia, or could we say that living law really has to be understood as, in every case, the same division, once again, between what ought to be, what actually happens, applies even to living law? And there I stop. Thank you.